maybe now. So I will make, of course, a summary of the report. It's quite a long report. Several issues are addressed. But essentially, as has been suggested, the main message is that if developing countries do provide patent protection in relation to plants, plant materials, or plant varieties, there is the need to introduce exceptions to get a better balance in the patent laws. And the fact is that European law does provide some lessons for that. So maybe these European precedents should not be followed exactly as they are, as we'll argue in a minute. But it's very paradoxically, perhaps, that European countries have reached in the area of patents as applied to agriculture a balance which is not found yet in developing countries. So next one, please, Vito. So I will first make an introduction. Then I will address the issue of patentability of plants and plant materials under European law. I will address the limitations to the patent rights, which are conferred under European law, and then try to get some conclusions and lessons for developing countries. Next one. Introduction. So the introduction. Next one. So let me just indicate for those who are not familiar with the terminology that is used in the report. I'm going to refer to plants. I'm going to refer to plant materials. So plant materials are components of the plant, such as genes or gene constructs, which are developed, for instance, with resistance to herbicide, as the very well-known Roundup Ready of Monsanto, for instance. This may be cells, this may be subcellular components as peptides, or this may be seeds. And then we have plant varieties. So sometimes there is some confusion between plants and plant varieties. Plant variety is a concept that encompasses the idea that you have a group of plants that share some characteristics. And in the context of UPOV, as we will see, this includes stability, uniformity, and novelty. So plant varieties is a group of plants, is not the same as the concept of plants. And this is important because patent laws make a significant differentiation in many cases in relation to the protection of plants or plant varieties. Next one, please. And this is just to show an example. These are examples of varieties in potato. In potato, more than 4,000 varieties have been identified. As you know, the countries of origin are the Andean countries. So within the same species, we have different varieties. Next one. And then this is one clear evidence of what plant variety means when it is based on uniformity. As you can see in this field, there is a significant uniformity in the plants. And this is one of the objectives of commercial breeding in particular, to get uniform varieties on the basis of hybridization in some cases, or the use of other techniques. So this is sunflower. As you can see, this will not happen in nature. In nature, you have different size, height of the plants. Next one. Then plant varieties can be developed on the basis of what we may call conventional breeding, which is based on the selection and crossing of different plants. In the last 40 years or so, new technology have been introduced, initially genetic engineering, which allows to introduce a gene which is not part of the genome of a plant in it, in order to get some particular result, as I mentioned, for instance, resistant to a herbicide, resistant to some pest or other conditions. And then more recently, gene editing. So these are then technologies available today in order to develop plant varieties and then improve the capacity to assist in addressing hunger and the food needs in all countries. Next, please. All right, so new plant varieties may be protected by breeder rights. So this is a sui generis regime that was initially developed in Europe, and then this led to the adoption of the UPOV Convention in 1961, was amended in 1978 and 1991. So breeder's right is a special category of intellectual property rights, are similar but are not the same as patents, as I will mention in a minute. So new plant varieties may be protected by the system which is called plant variety protection. Then plants and plant materials may be protected by patents. So I do say it may be protected because countries may also exclude plants and plant materials from the protection by patents, but as we will see, this is not the case in many countries, including in developing countries. For instance, a genetically modified plant is the subject of patent protection in many jurisdictions. Let me add that in some countries, but very few, plant varieties, that means is a concept that refers to a group of plants, can also be patented, but this is quite exceptional. This is a case, for instance, of the United States, Australia, New Zealand, but in most countries, plant varieties are not patentable, but plants, that is, plants as such or plant materials can get patent protection. Next one, please. Well, regarding the TRIPS agreement, the TRIPS agreement does contain a facultative exception for plants. So this is in Article 27, and is clearly stated that the members of the WTO may exclude plants from protection under the agreement. However, the TRIPS agreement does oblige to protect plant varieties. And then you can see why this differentiation is so important. There's no obligation to provide patent protection for plants, but there is an obligation to provide protection for plant varieties. And interestingly, in this case, the TRIPS agreement refers that this protection may be given on the basis of sui generis regime. UPOV, for instance, is a sui generis regime, but not the only one. It may be provided under patents or a combination thereof. So there are two standards in this field under TRIPS agreement. No need to protect plants, but this can be done. And there is an obligation to protect plant varieties, but a lot of flexibility regarding what regime is applied to these plant varieties, as it may be sui generis, patents, or a combination of those. Next one, please. Then, based on a previous study that was published by the South Center and also Oxfam, it was also made in cooperation with Oxfam, there was a survey made in order to understand what was the situation in terms of patentability for plants and plant materials and plant varieties in the Global South. This information is in connection with 126 countries. And then this study found that plants are excluded from patentability in 40% of the countries that were studied. So this means that in most of these countries, 60% of the countries, the exception that is allowed by the TRIPS agreement has not been incorporated. So then this study also has shown that plant varieties and essentially biological processes to produce plants and animals are excluded in 43% of developing countries, these 126 countries. And no specific exclusion is found in 17% of the countries. So this shows that the flexibility that is allowed by the TRIPS agreement has not been fully used by developing countries. In relation to the exclusion for plants in particular, it is not clear in many cases whether this exclusion also applies to plant materials, for instance, for a gene or a cell of a plant, or it only applies to the plant as such. I will make reference to this later on. Next one, please. So one of the worrying elements in relation to this matter is that even if plants are considered not to be patentable, or even if plant varieties are considered not to be patentable, there may be an indirect way of getting control on a plant variety, and this is on the basis of patenting, for instance, a material. If you patent a gene, if a cell is patented, then indirectly the patent owner may get the control over the plant which incorporates that cell or that gene, but also it may indirectly also get some protection or rights in relation to the use of a variety. And this, of course, may lead to an increase in seed prices and also limit the exercise of farming rights, in particular the right farmers to reuse, to save and reuse seeds. So the implications are quite significant. Next one, please. So there is one example. This is the Brazilian law, which makes a clear exclusion for plant materials and other genetic materials. So this is not very common. This is perhaps the single or very few laws that makes an explicit exception or exclusion for the patentability of biological materials found in nature, even if isolated, including the genome or RED+. So this is an important precedent. I mean, it might be interesting to see whether this might become a model if there are amendments to the patent laws in other developing countries. Next one, please. So, as I mentioned, there are differences between the plant variety protection, the sui generis regime that I referred to before, and patents. In the context of the plant variety protection, one important element is the so-called breeder's exception. So this means that even if a plant variety is protected, commercialized, any other breeder can use this variety in order to develop and commercialize a new variety. So the protection based on plant variety protection will not limit the further research and breeding on the basis of a protected variety. And also under the plant variety protection, there is an important exception, which is generally called the farmer's privilege, which refers, as I mentioned, to the right of farmers to save and reuse seeds. But this is different, I might say, in the different versions of the UPOV Convention. While under UPOV 1978, the farmer's privilege is untouched, it may be exercised. In the case of UPOV 1991, as revised, this is an exception that must be implemented under national law. So there is no automatic enforcement of the farmer's privilege in the 1991 UPOV Convention. And then in the case of patents, the exceptions to the exclusive rights are far more limited in principle as compared to plant variety protection. For instance, in many laws, the research exception is provided for. There are other exceptions, such as the Adebola exception, which is applicable in particular in the case of pharmaceuticals. But patents provide generally stronger rights as compared to plant variety protection. And this is one of the matters of concern, because if plants or plant materials or plant varieties are subject to patent protection, then this means that the legal monopolies may be exercised with a broader scope as compared to plant variety protection, and then the rights of the farmers are constrained significantly. Next one, please. Okay, then as a first takeaway of this introduction, the best policy approach for developing countries would be to exclude plants as authorized explicitly by the TRIPS Agreement. Also, certainly to exclude plant varieties from patent protection and plant materials. And all this is certainly allowed under the TRIPS Agreement. But as I mentioned, and it was indicated by the previous study made by the South Center, there are patents which are granted in many developing countries in relation to these materials, in particular to plants and plant varieties. And then the question is, if this is the situation, if patents are granted, what kind of exceptions should be allowed in order to balance the protection with the interests of farmers and more generally society? And in this way, in this aspect, there are some lessons that we may take from the European legislation, as we are going to see. Next one. Next one, please. All right. And the European Patent Convention and also the Directive on Biotech Inventions. So these two regulations are important to look at this issue. Plant varieties are not patentable. The same applies to quite a vague concept of essentially biological processes that are used to obtain a plant. So in accordance to the European Patent Convention, neither the plant varieties nor the essentially biological processes to obtain a plant variety are patentable. So this is quite an important element, and this may explain perhaps why the United States was not successful in the negotiation of the TRIPS agreement to get a different solution for the protection of plants and plant varieties, because Europe was not, at the time of the negotiation of the TRIPS agreement, ready to change its own legislation based on the European Patent Convention. But then under European law, plants, for instance, a genetically modified plant or plant materials are patentable, including isolated genes. So if a gene is isolated from a plant existing in nature, this is patentable under the European law. Well, as long as it is indicated in the slide, as the technical feasibility is not confined to a particular variety. So the European law is quite strong in preventing or attempting to prevent the patentability as such of plant varieties, but as it's shown here, it has quite a broad scope for patent protection in relation to plants and plant materials. And this is problematic, as I mentioned before, because on the basis of patenting the latter, you may get indirectly the control of plant varieties. Next one. In relation to this concept of essentially biological processes, which is, as I mentioned, excluded from patentability, there has been a lot of discussion, debates, and jurisprudence, in particular by the European Patent Office. So how to interpret this concept? And the essential criterion to determine whether a biological process is essential or not is the degree of human intervention. And there were a couple of cases in the past which were decided by the European Patent Office, the cases of tomato and broccoli, in which there was a very interesting discussion about this concept of essentially biological. It was very interesting to listen to different interpretations coming from different stakeholders. But finally, the European Patent Office came to the conclusion that essentially biological processes are not patentable, even if some techniques for screening are used. But then there was an indirect reversal of this decision when it was admitted that although the process itself was not patentable, the product that was obtained on the basis of the use of that process could be patented. And then there were a number of conflicting decisions on this in the context of the European Patent Office. There was also an intervention by the European Parliament against this possibility of granting a patent on a product, which is the result of the essentially biological process. And then finally, the European Patent Office reversed its position on this in this case, which is mentioned in the slide, the pepper case, and clarified that a product which is obtained through essentially biological processes is not patentable. Next one, please. So then, as I mentioned, the scope of patentability in the context of European law of patents of plants and plants-related material is quite broad. But there are a couple of limitations to this scope, which is worth mentioning. One relates to the patents on genes. As you know, a gene may have different functions. And if a gene is patented, and in Europe, for instance, an isolated gene, even a human isolated gene can be patented, then all possible functions of the genes will belong to the applicant or the patent owner, even if the patent owner did not identify them. So even for functions that the patent owner has not identified, his patent will cover any possible use, commercialization, etc. of any product containing the gene. Then in Europe, an interesting doctrine has been developed, which aims at limiting patents on genes to the use or the function which is specifically described in the patent application. So this means that they apply the concept that is generally called a use-bound claims. So this means that when a patent is applied in connection with a gene and a patent is granted, the protection is only given in relation to the function which is specifically described and not to other functions that will be unknown. And this is a significant step, which is not, as far as I know, for instance, a practice in developing countries, in which there may be also patents on gene. And there is a second limitation on the scope of protection, which is also of interest. And this is that if a genetic material is patented, for instance, a genetic construct to provide resistance to a pest or to herbicide, which is incorporated into a plant, which is genetically modified, then in accordance to the European law, and this has been confirmed by European Court of Justice, protection only takes place when this genetic information performs its function and not beyond that. And this was discussed in particular in a case that was brought by Monsanto against exporters of soya flour from Argentina. And Monsanto argued that the importation of soya flour, that means material in which the gene was not performing anymore any function, was in any case an infringement of the patents that Monsanto has got in Europe. But then the European Court of Justice rejected this view and confirmed that under European law, the protection of genetic information, which may be contained in plants, is only valid during the time in which this genetic information is performing the function, and not in a material such as flour or other product which has been elaborated on the basis of genetically modified plants. Next one, please. Well, here is an example of how French law, this also included in other laws, other European laws, limit the scope of patentability. In the case of the French Industrial Property Code, this was amended in 2004. It is said the scope of a claim on a gene sequence is limited to that part of the sequence directly linked to the function specifically disclosed in the specifications. And it clarifies such a claim cannot be enforced against a subsequent claim on the same sequence that discloses another specific application thereof. So it's clearly stated that if a gene is patented, it will also be the function, specific function, which is protected. Next one. And this is also a statement from the General Advocate of the European Court of Justice in the case that I referred to, who clarified that the Biotech Directive permits and in fact requires an interpretation to the fact that in the European Union territory, the protection conferred on DNA sequences is a purpose-bound protection. So this is a clear indication that the European law will not allow the protection beyond what is specifically described in the patent application. Next one, please. This decision is also interesting, and this is a decision that was done in December 2019. And it shows a concept by the European Court of Justice that I think it would be useful also to be taken into account in other jurisdictions. I will read it. I will read one paragraph of this decision. It says, even though the scheme introduced by the European Union is intended to grant protection to breeders who develop new varieties in order to encourage in the public interest the breeding and development of new varieties, such protection must not go beyond what is necessary to encourage such activity. Otherwise, the protection of public interest, such as safeguarding agricultural production and the need to supply the market with material offering specified features, or the main aim of maintaining the incentive for continued breeding of improved varieties may be jeopardized. So this is interesting that the European Court of Justice makes a call for a balance in the protection of plant varieties. Next one, please. Okay, so now, as we have seen, the scope of protection in Europe is quite broad, although limited in some respects. But then, and this is the last part of my presentation, what is interesting that the European law has looked at ways in order to limit the exclusive rights which are granted in relation to plants and plant materials. Next one, please. And this is done in a way that aims at mirror to some extent some of the exceptions which are provided for under the plant variety protection. One of them, as we have seen, is the farmer's privilege. So these rights for the farmers to save and reuse seeds. Under the directive, the so-called Biotechnological Inventions Directive in the European Union, there is a farmer's privilege which is recognized. And the same you can find in the patent laws of Germany, Netherlands, Austria, France, and also outside the European Union of Switzerland. So it's interesting that these farmers' rights has been, or the farmers' privilege has been recognized. This is not, unfortunately, the case in developing countries. So this is why the European law may provide lessons for our countries. There are some limitations, however, to this concept of farmers' rights as applied in the context of patent laws in Europe. One restriction is this privilege is applicable to only some agricultural plant species, but if developing countries choose to follow this approach, there is no reason why they should limit it to some species. This privilege should be applied to all species. In some cases, there is an obligation to pay a remuneration, an equitable remuneration, which would be lower than the remuneration paid originally, but small farmers are excluded from payment of this remuneration. And there are some other restrictions in relation to the possibility of not to sell and exchange the seeds. But in any case, as a matter of principle, it's interesting that under European law, the farmer's privilege has got some kind of recognition. Next one, please. Well, the same applies to the breeder's exemption. As I mentioned, the breeder's exception is a typical feature of plant variety protection. This allows a breeder, as I did mention, to use a protected variety to develop a new variety. So this is also mirrored now in the patent laws of several European countries, and it's also included in Article 27 of the most recent Unified Patent Court Agreement. So this exemption allows any breeder to use patented material to undertake further breeding or research and develop other plant varieties without the consent of the patent owner. So this is a full exception. But there is a difference between this exception and the exception under plant variety protection. Next one, please. And the difference is that under the plant variety protection, the breeder's exception allows the new breeder to do research, to do breeding, and then to commercialize the new variety, except in the case under report of 1991 of the so-called essentially derived varieties. So this is a limitation to the breeder's right. But if there is no essentially derived variety, in principle, the new breeder can not only do breeding, research, but also sell without the need of the consent of the original breeder, the new variety. But this is not the case under the exceptions that we have just looked at in the patent laws of European countries. In this case, the exception only concerns research and breeding, but it does not go as far as allowing also for commercialization. This provision, as provided for in European law, is clearly compatible in our view with Article 30 of the TRIPS Agreement. In fact, there has been no claim whatsoever against any European country or the European Union because of the recognition of the farmer's privilege or these exceptions in relation to the breeder's rights. The question is, however, whether it might be possible under patent law to go further. That means to have the breeder's exception, which is fully equivalent to the exception under plant variety protection, meaning that the breeder would be allowed not only to do research and breeding, but also to commercialize the new variety, which is developed on the basis of a patented variety or patented materials. So this has been discussed quite a lot in the literature. There is no clear conclusion, but this is an issue that deserves further exploration. Next one. And then another element in the European law is that there is a regime for compulsory cross licenses in the case that there is, in relation to a particular plant variety, cumulative protection based on plant variety protection and also patent protection. For instance, if there is a plant variety in which there is a gene or a gene construct which is patented, so there may be two sets of rights that will affect the use and commercialization of such a variety. Then under the European law, there is this concept of compulsory license, cross-compulsory license. If this cumulative protection arises, either the patent owner or the owner of the breeder's rights can apply for a compulsory license if there is no agreement between the parties. This compulsory license is subject to a number of conditions, for instance, that there is no success in attempts to have a license, and that the plant variety protection or the invention constitutes a significant technical progress. So the conditions under the compulsory license system in the European Union, in our view, is very restrictive and it's very difficult to meet those conditions, but it actually highlights the policy space that countries may have in the cases in which these materials are subject to patent protection, and then perhaps compulsory license can be provided for, but without the constraints that are present in the European legislation. Next one. Then to reach the conclusions, the best approach in this field is not to grant patents in relation to plants or plant varieties, for sure, and also to avoid the indirect control through the patenting of components of a plant, being these gene, cells, etc. So this is the best approach. But if this is not the case, if patents are granted in relation to plants, for instance, genetically modified plants, or in relation to plant materials or components such as a gene construct, then in this case, it would be advisable to look at this legislation in Europe and to take some lessons from it. In the first place, about the scope of protection of genes, if granted, it will be important to introduce these use-bound claims that I've explained. Secondly, it will be also important to introduce this limitation that protection of genetic material is limited to the time in which this material performs its function. So this is another important limitation to patent protection in this field. Thirdly, it would be important to clarify what is meant by essentially biological processes, and in particular to the fact that a product obtained through the use of essential biological process is not patentable. Fourth, it might be important to introduce farmers' privilege in national patent laws. So again, here there is an example provided by European law. There is no need, as I mentioned, to limit such a privilege to some crops or to limit to some kind of farmers. It would be broader than that. And the fact that it's already provided for in European law is an evidence that this is a compatible exception with the TRIPS agreement. Then fifth, it would also be important to introduce a breeder's exception that mirrors the exception and the plant variety protection. And then still to explore the scope of this exception, whether it should be a full exception, including commercialization, or just be limited, as it is the case in European law, to breeding and research. And sixth, then incorporation of compulsory cross-licensing for situations of cumulative protection, also shown by the European legislation. So in the end, so developing countries, I think, would benefit while looking at this legislation, making an appraisal of the extent to which some of the ways in which the European Union and some European countries, including Switzerland, have dealt with these issues, and how this can be the basis for further clarifications, eventually amendments in the patent laws of developing countries. Well, thank you very much, and I'm, of course, open to any questions.
Thank you, Professor Correa, for that very clear presentation of what is, like you mentioned, a long study, but I think you presented it very clearly in here. So I would like to, first of all, just let our participants know that we have the Q&A open, so you might pose questions for now. We will go first to the discussants, and then after we've had the discussants speaking, then we'll come back for more discussion based on the Q&A. So please do include those questions for now or hold them for later if you'd like to. I'd like to give the floor now to our first discussant, Bram de Jonge, who is a seed policy advisor of Volksbank Novi, and he's also a researcher in law and governance group at the Wageningen University in the Netherlands. Bram, to you.
Thank you so much, Viviana, and thank you so much, Professor Correa, for the clear presentation. I've been asked to briefly tell you a bit more about Oxfam's position on the patenting of plants. I will do that very briefly because so much has already been said by Professor Correa. So I think, so I hope you now see my screen full. I think the key issue for Oxfam is coming down to this graph where you see on the top line in blue the annual number of patent applications in the WIPO in the field of related to plants, and below in green the number of patents on plants granted by the European Patent Office. And so on an annual basis, you see the steady increase of the number of patents on plants, plant genetic materials, and the methods to produce them. And given the fact, as Correa explained, that each patent, by allowing for the patent of plant parts, be it the genetic material or technical processes for the production of plants, the patent law practically or potentially allows the patent owner to get exclusive control over the future use of any plant and any plant variety that incorporates the patented component, is produced through the same process, or simply shows the same characteristics. And this protection may extend to the food or feed that is produced or derived from the patented plant. And I would say that for Oxfam, this is the basis, the basic reason why we are troubled by the steadily increase of the number of patents on plants. And we actually only think and fear that with the introduction of gene editing technologies, that this number will only increase further, even exponentially, and that it also will be much more difficult to see which plants are gene edited and which are not. So the scope of patents, of patent protection, will become totally unclear, meaning that it will be very difficult for farmers, for breeders, which are not supported by a truckload of lawyers, to know what their freedom to operate is, to know what they can use or not in their plant breeding programs, in their fields, when they do as a farmer selection and further crossings. Where are the lines of what you are legally allowed to do and what you are legally not allowed to do? And with that uncertainty, I think that is not what we want in the current state of affairs, where there are plenty of challenges that we need to face as a society. So this is the core reasons why Oxfam is alarmed by the current process. As we stated, the growing number of patents on plants and plant parts and the broad scope of many of these patents narrow down the pool of plant genetic material that is freely available for further breeding. And next to this, and very much related, is that we also see the steady centralization in the sector, being fewer number of companies that dominate the market. So these few players, they have a larger share of patents in their hands, and they dominate the global seed market, further strengthen their control over the seed sector and may threaten global food security in the long run. So this is also related to the complexity of the system, how costly it is to manage, to navigate, and to enforce patents, which makes that smaller companies, but also especially public plant breeders, which cannot compete with the legal expertise and the financial resources of the big players, making plant breeding more and more dependent on lawyers instead of breeders. We also see a problem in connection to farmer rights. The main access to seeds for the millions of smaller farmers in developed countries is through the storage, use, exchange, and trade of farm-safe seeds. This is a vital source, but may be blocked when patents on plants and plant genetic material are enforced against these farmers. So, if that happens, smaller farmers may be criminalized from the main practice of accessing seed. And since it may not matter whether a farmer deliberately plants and grows a patented seed on his or her land, any farmer may be vulnerable to patent litigation simply because the wind may bring pollen from a patented plant into his or her fields. We also fear, it's a final point, that patents can facilitate biopiracy. Patents may be granted on innovations that are based on the knowledge and plant genetic resources of traditional communities from developing countries without their prior informed consent or any form of recognition or benefit sharing in return. And this can come through many different trajectories. The traditional knowledge of indigenous communities or local farm communities may not be consulted or be accessible for the consultation of prior art by the patent offices that grant the patents or not. The patent criteria may allow for the patenting of incremental innovations or simply of the identification and isolation of an active component of a plant that has been known and used for centuries. Few countries require the disclosure of origin and proof of legal provenance of an invention related to existing plant genetic resources or traditional knowledge. And often remains unclear how and from where and when particular resources were acquired that form the basis of a new invention. And that's why this practice of patenting can facilitate biopiracy. So for all these various reasons, Oxfam believes that no patents on plants or plant parts should be allowed, and that all farmers and breeders should have unrestricted access to all the building blocks of life. But then, as we see that many countries do allow for the patent of plants, sometimes explicitly, sometimes more implicitly, as Professor Correa explained, we think it's useful to be aware and conscious of the various exemptions that could be included in existing patent laws. So if countries decide to allow patents on plants, Oxfam recommends the implementation of provisions that maintain the accessibility of plant genetic resources for further breeding and minimize the adverse effects of patent legislation on society in general and indigenous peoples and smaller farmers in particular. So with that, I would like to thank you, and I'm looking forward for the discussion. I hope we will have some discussion in the remainder of the session.
Thank you, Bram. I will move now to our second discussant, who we know have a scholar who's a lecturer in law and theme coordinator for IP law, and that is Professor Titi Adebola. It's great to have you with us. Thank you very much. And just to remind you, we can keep to 10 minutes. Thank you very much. Please go ahead, you have the floor.
Thank you very much, Viviana. And thank you, South Center, for the invitation. I've thoroughly just enjoyed just listening to the sort of interventions, first of all, on the presentation of the brilliant study and just the way Professor Correa has sort of outlined it and discussed such an important topic for the perspective of how developing countries or global South countries can sort of learn or draw insights from what Europe has done with regards to patenting of plants and exceptions to plant breeders' rights. And also I acknowledge Bram de Jong's sort of intervention and perspective from Oxfam. I would say that for me, I decided to approach my intervention from the perspective of Africa. So I've done some work on plant variety protection in Africa. And since the task was to have a conversation about how developing countries can learn from the work that Europe has done with regard to the subject, I thought that perhaps we could have just a conversation about what is happening on the continent in Africa. And I also use an example from Nigeria, which is one of the newest countries that has introduced a plant variety protection law on the continent. And I would agree with, first of all, with the study. I agree with the context of the study and the recommendations from the study. And we know that the history of plant variety protection or the extension of intellectual property to plant varieties has been complex. So we know that, from the 1930s, when we had the introduction of laws in the United States, there have been questions around, first of all, whether we should extend proprietary rights to plant varieties. And that was sort of overhauled through a progressive approach in the United States. And we saw that with the first Plant Patent Act and then progressive sort of laws. We saw the first international treaty with the International Convention on Protection of New Varieties of Plants. And from there, we have seen an extension of both patents and plant breeders' rights systems through UPOV extending around the world. Professor Correa rightly said that we have only a limited number of countries that have decided to extend patents to plants and plant varieties. But then we realized that even though the history of the extension of patents and plant breeders' rights or the introduction of these subjects has been from the West, so from the global North, like we said, with the example from the United States, with the example from Europe, we see there's also been a clever way of interpreting the provisions that had been set out. And so we see here that even though the subject is complex, lawmakers and policymakers in Europe have designed nuanced institutional, administrative, and judicial frameworks to expand the boundaries and contours of the laws that had been introduced to suit their domestic realities. And Professor Correa has given us brilliant examples from Germany, Netherlands, Austria, France, Switzerland. And even though there had been contestations about the conceptualization of certain terms, we have seen how those terms through some of the case law, so we have Novartis, we have the tomato broccoli cases, we see how the peppers cases, we see how institutional and judicial frameworks have been able to expand sort of the contours of the exceptions that were introduced under the European Patent Convention, and also the laws that we have with under the European Community Plant Variety Protection laws, which interpreted UPOV 91. Now, the question is, how can other jurisdictions then also work within this international legal framework that has been extended to them, even though we know from the sort of the context of the negotiations of these international laws that countries in the global south raised some objections to the introductions of these laws. So we know that during the TRIPS negotiations, for example, there were questions about extending provisions like access and benefit sharing or farmers' rights, but we see that those were sort of marginalized from the outcome. So we see in Article 27.3b a contestation that reflects the questioning between the United States and Europe. So United States then through case law had agreed on extending patents, utility patents to plants or anything under the sun made by man, Diamond versus Chakrabarti and the other case laws there. But we see that Europe was still circumspect in that regard. So Europe said no to patents for plant varieties. But then we have seen, like I mentioned in the previous slides, how Europe has interpreted that. Now, in the context of Africa, Africa's response to the debates and the discourse at the international level was its introduction of the African Module Law. And one of its provisions then was that it was saying no to patenting of life forms. So Article 9 of the African Module legislation for the protection of the rights of local communities, farmers and breeders, and for the regulation of access to biological resources prohibits the patenting of life forms. So that was sort of the response, and that was the position of Africa at the point. However, Africa also went a step ahead and introduced its own interpretation of what we would say farmers' privileges would be, if you like, but it uses the language of farmers' rights. So it uses the language from the FAO, the International Undertaking, the International Treaty on Plant Genetic Resources for Food and Agriculture, which was adopted afterwards. And it provides for the protection of community rights, provides for the protection of farmers' rights. But we see that there has been limitations in the implementation of these provisions because there have been a socialization, there have been bilateral agreements, foreign investments that have promoted or fixed a certain normative interpretation of the international obligations in Africa. So you see many African countries now designing plant variety protection laws that are based on the UPOV 91 convention, which Nigeria is also an example, like I will mention in my next slide. However, they have not borrowed the same way Europe, the European examples that we have given, have expanded their own interpretations of the privileges. These countries have not been able to do that. So that would be a question, or that would be sort of a point to note with regards to the lessons and the insights that Africa can learn. We also see that, so we have two regional, sub-regional intellectual property organizations in Africa, OAPI, that's for mostly Francophone Africa, and ARIPO, mostly Anglophone Africa. OAPI introduced the Bangui Agreement, which is also based on UPOV 91, but we don't see the same types of exceptions in implementation as we've seen from the examples from Europe. And we also have ARIPO. So ARIPO has sort of adopted the Arusha Protocol, which is soon to enter into force if they have the right number of sort of ratification as in line with the provisions. And that is also styled on UPOV 91. So you see a continent that is adopting an European styled convention, but has not introduce the same types of exceptions as we have seen that Europe has carefully constructed in ways that suits their own domestic realities. And that would be the call, or I would say for my intervention. Nigeria, in its patent law, also under section 1.4, prohibits the patenting of plant varieties, but its new plant variety protection law introduces provisions such as, providing that exceptions for plant breeders' rights should be based on the legitimate interest of the plant breeder. And the question will be, how do we interpret the legitimate interest of this plant breeder? So we have not gone as far as introducing institutional, administrative, or judicial sort of standards to help with interpreting the exceptions that have been introduced sort of to take into consideration the interest of farmers, which I would believe was the intention of the lawmakers. So even though the law was promoted, was supported by UPOV, the UPOV office, there are questions about whether, as Professor Correa has challenged us, whether at the ground level, the national policymakers would be able to work within the parameters and the exceptions to introduce similar exceptions for the country. And so I would just go to my final slide just says that African countries have the policy space to carefully implement their international obligations through laws and policies that will be suited to their domestic realities. We should remind ourselves that on the continent, we have about 70 to 80% smallholder farmers. Therefore, the types of exceptions and limitations should take into consideration their interests. So we have questions about saving, using, reusing, and selling farm-safe seeds, whether they are branded or unbranded. I think some jurisdictions that have done that have been unbranded, and those are some of the examples that the continent can learn. So we see that European examples demonstrate how global South countries can work within the existing international legal regimes to introduce domestic laws that protect the interest of the large populations of their small-scale farmers. Some of the questions moving forward will be whether there is expertise to design such exceptions on the continent, and then how would the institutions and the judiciary, work with implementing or introducing their own jurisprudence that helps us understand the implementation of these laws. And then we also know that even though some of African countries would be interested in working within or expanding the apertures and boundaries of these laws, we know that there are some limitations through foreign investments and bilateral agreements. So that would call for some conversations. Thank you, and I look forward to just questions and discussing this further.
Thank you very much to Professor Titilayo Adebola, really bringing us more into the regional and domestic context, and again reminding us that there is this policy space within the international legal framework, but that needs to be used adequately. And then at the same time that we should also try to ensure coherence between the different legislations being put place that sometimes might have some contradictions in the implementation, as was exemplified in the presentation. So I think that very complementarily, we have now Mr. Tanyaradzwa Manombo, who's counselor at the Permanent Mission of the Republic of Zimbabwe at the United Nations office here in Geneva. And Tanyaradzwa, I think you have a presentation. Feel free to share your screen, and the floor is yours. Thank you very much.
Good day. I hope you can hear me clearly now. Just getting my electronics correctly. Okay, I'll go right ahead. Thank you very much for inviting our delegation to make a presentation. My name is Tanyana Zwanombo, as you've rightly indicated. We'll start by congratulating the South Center on completing this very useful study. And we hope and we are sure that policymakers, both in Africa and elsewhere, are going to find this study very useful. So my study is basically going to follow, I think, everything, the advantage of coming in last or later after respected and, well-known presenters such as Professor Korea, Dr. Adebola, is that they've pretty much done all the work. And so I'll just make a very brief intervention, particularly focusing on Zimbabwe. Okay, so for Zimbabwe, we are a member of a number of organizations which have a number of international treaties which relate to plant breeder protection. The first one being the WTO with the TRIPS Agreement, WIPO, we have the UPO system. Of course, we are not a member, but we are an observer, and we do continue to observe the process. For ARIPO, as has already been explained by Dr. Adebola, there is a protocol there, but it's not yet in force, and we have not yet signed on to that protocol. We do have the Africa Continental Free Trade Area, which is new. There is an IP protocol being negotiated under that free trade area, and it's not yet clear whether plant protection would fall under that IP protocol, but it's something that we will see as the negotiations go forward. We also are a member of the Southern Africa Development Community, which also has a protocol for the protection of new varieties of plants. We are not a member of that, and that protocol is not yet in force. We are a member of the ITP-GRFA, it's an FAO initiative, again, which relates to the overall process. So what this tells you is that we have a number of protocols and instruments relating to the regional organizations and international organizations which we are a member of, which relate to plant breeder protections in Zimbabwe. Sorry. So in Zimbabwe, since we're not a member of the UPO system, we have our own sui generis plant breeder rights system. We have Plant Breeders' Rights Act. It's pretty old, from 1973. It's something that I think we inherited in our colonial era. Then it's enforced in conjunction with our plant breeders' rights regulations. And it's administered by a registrar of plant breeder rights who is housed in our Ministry of Agriculture. As a member of the WTO, we have domesticated the TRIPS agreement in our patent laws and other IP-related laws. And we have domesticated Article 27.3b, which we've incorporated in our Section 2A, B, and C of our Patent Act. And we also have provision within our Constitution, Section 33, which talks about preservation of traditional knowledge. And what this particular section says is that the state must take measures to preserve, protect, and promote indigenous knowledge systems, including knowledge of the medicinal and other properties of animal and plant life possessed by local communities. So what this says is that any action which the state must take in relation to particularly traditional knowledge systems must in fact protect and preserve the traditional way of life of our local communities. We do have what we would call farmer exception or privilege. This is in our Section 17, paragraph 3 of our Zimbabwe Plant Breeders' Rights Act. And you'll notice that the part A there is a breeder exception, as has been highlighted by Professor Correa. I think he explained that quite well. And then the second one, which is paragraph B, is sort of a first sale doctrine, where there are use rights for the users of the seed who are allowed to actually use the seed to grow the plant and to sell the harvest, or to resell a plant. I suppose if you're into nurseries and things like that, and you want to resell the seed to farmers, you should be able and allowed to do that. We also have very interesting provisions in our paragraph C and D, which relate to particularly farmers, and that's our small scale farmers. And particularly in the part C there, you see that where a farmer cultivates less than 10 hectares of land, they may use the harvest from the prescribed plant for the purpose of propagating the plant on that land, where the harvest was obtained by propagating the plant on that land. Basically, this is to protect our small-scale rural farmers. Again, in D, we have a provision which basically says that where a farmer derives at least 80% of their annual gross income from farming on communal land or resettlement land, as defined in other sections, they have an exception. Again, this is to protect our small-scale farmers and our communal farmers. So I think I'll conclude there and just reiterate what has been stated by previous presenters. Coherence is very important at national, regional, and international level, but particularly looking at an African perspective. I think, as I've highlighted, we're a member of ARIPO, an IP filing system within Anglophone Africa, but we're also a member of the Southern Africa Development Community, and there are already two potential regional systems for plant variety protection. And although they are both partly based on the UPOV system, there are some differences in those protocols, and it does sort of create conflicting kind of policy choices should Zimbabwe sign up to both those protocols on how to reconcile the differences. And as has been highlighted, PBR must be balanced with flexibilities to guarantee food sufficiency and farmer rights. So thank you very much.
Thank you very much, Titaniratso Amonhomo. Now I have the pleasure to introduce Ms. Susan Amar, and she is a biotechnology patent examiner with the Egyptian Patent Office. So surely her perspectives as well from examining these patents in detail will also enlighten our discussion. So Suzanne, you have the floor, and thank you for joining us.
So good evening, everyone. I'm Susan Amar, biotechnology patent examiner at the Egyptian Patent Office. And my presentation is concerning concerning the technical examination of patent application related to plant protection. First of all, there is a common understanding that plants already present in nature can't be patented since they constitute a mere discovery. In fact, there is an assumption that patenting plants and their seeds allow control over their distribution and the subsequent production of food. The production of plant varieties may negatively affect agricultural production and the interests of farmers. The expansion of the use of genetic engineering may affect the safety of the environment in the future because the long-run safety of a genetically modified plant can't be known. So it may lead to the extinction of natural varieties or wild types. For the exclusion of plants from patent protection in the Egyptian legislation, the Intellectual Property Rights Protection Law number 82 of 2002 excluded the protection of plant varieties by patent, as the second article of the law decided not to grant a patent for plants and animals. The Egyptian legislature chose to protect plant varieties through a system of special type of plant variety protection that in many respects complies with the provision of the 1991 UPOV Convention. The exception of patentability under Egyptian patent law article 2 items 4 and 5 states that plants and animals, regardless of their rarity or peculiarity, and essentially biological processes for the production of plants or animals, other than microorganisms, non-biological and microbiological processes for the production of plants or animals. Item 5 for the article number 2 states that organs and tissues, living cells, natural biological substance, nucleic acid, and genome can be patented. So to summarize, what is not patentable in the Egyptian law for the plants? Newly invented plants that are either sexually or asexually reproduced. The transgenic plants which was genetically engineered to improve its properties or yield, or to promote or suppress its growth. So the plants and the plants and their products can be patentable under the Egyptian law. Specific plant varieties, seeds, parts of the plants, and the plant tissues also not patentable. Also, the biological process for the production of the plants, which consists entirely of natural phenomena such as crossing or selection. And finally, the discovered plant. What is the patentable under the Egyptian law for our work as patent examiners? Is the process of treating a plant characterized by the application of growth-stimulating substance or radiation, and the method of producing a transgenic plant which exhibits an improved feature, for example, by integrating the double-strand RNA into the genome of the plant cell. That's all about our work as technical patent examiners. And thank you for joining that discussion. Thank you.
Thank you so much, Suzanne, for enriching the discussion with those elements of how examination is being applied with regards to the Egyptian Patent Office. And this brings us to some of the questions by participants in the Q&A. So I'll first take two related ones and then ask for panelists if you'd like to go ahead, or I might suggest to save some time. So one is with regards to the issue of the new tools such as CRISPR and gene editing. How does this relate in terms of the use for plant breeding or the patenting? And would plants that result from such tools be patentable in countries that allow patents on plants? And a related question is, are there alternatives to the grant of patents on such gene editing technique, such as CRISPs, used in agriculture, but also in plants? So if we still want to incentivize this sort of innovations, are there alternatives to patents as well? And is it related question as well, would it be possible to introduce new exceptions for such potential type of new innovations when they're based on the use of these new techniques? Perhaps I might point that to Brande Jonge or to Professor Correa.
Well, thank you so much. Well, I think that that I'm also very much looking forward to hear Professor Correa's views as an expert on this. Regarding the incentive functions of patents, because that's, I think, a major argument which is often being made against at least our proposal to dismantle patents for the breeding world, is that without patents on these biotechnologies, there will be no incentives anymore for investing in these new technologies. But I do think, I think that if we look at who invented the new gene editing technologies, in principle, and also in the past, many of the key new technologies, the first inventions come from the public sector. It's made by public researchers based on public money, and the building blocks and the tools, the toolbox is being filled through the public sector. And then very soon, especially with these technologies, because they are patentable, the private sector steps in and takes it further. I do think that if patents would not exist or not be available within the plant breeding environment sector, then still these technologies, if they are found useful and safe to use, they will still be used by any breeder if it's promising and if they are helpful in the breeding process, without or with or without an IP incentive function. So I think that, in my personal opinion, but also from Oxfam, is that plant breeder rights system provides enough incentives already, and is a simple, relatively simple system that breeders can understand without the need for lawyers to navigate. And it's very clear, because of the broad breeders exemption, that that anyone is able to use any protected material for further breeding. So to us, let's base it on that system, look how we can make that better for all stakeholders involved. And then we do not need the patent system as an incentive function in plant breeding. That's, well, I'm happy to hear other thoughts and from other. Thank you.
Professor Correa?
Well, thank you. Thank you, Viviana. Well, in the first place, I think discussion should focus on whether a new plant variety or a modified plant based on the use of CRISP technology should be patentable or not. Certainly, it would comply with a standard of novelty, but I think getting the standard of inventive step in many cases may be difficult if it is applied in a rigorous manner, because in fact, once you know what the objective is with the use of this gene editing, the technology is known, and the question will be, where is the inventive step? So therefore, I think there's still a lot of consideration to be made. I will argue that it will be important for developing countries. The Egyptian Patent Office has already provided a model in the area of pharmaceuticals, how the standards of patentability are applied. It would be good for developing countries to look at this, perhaps also to have some cooperation, the context of some cooperation, to see how these patent applications should be dealt with. So I'm quite skeptical about the extent to which this patent should be granted if the criteria for patentability are strictly applied. So regarding incentives, I agree with the comment just made by Bram. So the patent system is not the only, neither it is not the best system of incentives. So there is a lot of literature on this. There are many economic studies, some of them conducted in the United States also. So the major incentive is to be first in the market, and this is already a major achievement for the innovator. And then on this basis, it is possible to get the reward for whatever investment has been made. So I think there is a need certainly to think alternative, which are not based on the monopolization of the outcomes of the research, which is essential for the progress of agriculture and for feeding people. If you allow me, I would also like to make a short comment about one of the observations made by Bram in relation to the possible extension of patent protection, not only to the product as such, but also to food or feed. In fact, many of the patent applications that were reviewed for the study, in particular the first study, actually claim not only the process to obtain a particular output, the product which is obtained, but also any food or feed which is produced on that basis. So this is also a matter of concern, and I hope that the patent offices also take the right approach in order to prevent this expansion of protection. Thank you.
Thank you very much to both of you. Now, I'd like to just come to another of our participants' questions. And this is that with regards to the overwhelming evidence against the benefits of patenting plants, why do we still see a low implementation of TRIPS flexibilities in developing countries? Is it, countries don't use the provisions, or is it lack of legal expertise or lobbying multinationals? Perhaps I can address that to Tililayo or to Taniretswa?
Thank you, Viviana. I think that there are a number of reasons why countries have not been able to adopt or implement the flexibilities that we have under TRIPS. So I mentioned that there might be limitations through bilateral trade agreements. So while a country, for example, might decide that they want to introduce a sui generis type of plant rights protection law, they might have signed on to a trade and economic partnership agreement or investment agreement that mandates them to introduce UPOV 91. And that would limit their ability to use the flexibilities in TRIPS. Also, some countries might not understand, some policymakers and lawmakers might not understand sort of the complexities in the conversations around plant variety protection. So I was having a conversation with policymakers in an African country, and they said that they wanted to adopt UPOV 91 because they wanted to meet international standards. So they didn't quite understand the flexibility, the latitude that they had with regard to Article 27.3b. Rather, they were sort of encouraged and incentivized by the type of grants and by the type of technical support and capacity building that was offered by the UPOV. And they thought that that was the only way of them implementing the sui generis option in Article 27.3b of TRIPS. So I would say that there are a layer of reasons why countries might not be able to adopt or utilize the flexibilities in TRIPS, which is political, and also we have socioeconomic reasons that would sort of inform that choice, like I've mentioned.
Thank you. And Taniretswa, would you like to add anything else on this point?
I think Dr. Adebola has basically mentioned almost everything. Of course, the TRIPS Plus provisions, I think they're very common now in almost all bilateral investment treaties, in all regional trade agreements. And this definitely constrains a lot of developing countries to make use of flexibilities. And it's also important, for policymakers or negotiators, when they are negotiating these treaties, to try and seek as many carve-outs as possible, especially in the bilateral investment treaties, where we see a lot of these binding TRIPS Plus provisions. So thank you.
Thank you very much. I'll pass the last question I'll be able to take, because we're running out of time, to Suzanne as a patent examiner. There's a question with regards to the difference between plant breeders' rights and patents for plants or parts thereof. And the question is, why would the plant variety protection not be subject to the same exceptions and limitations as the patent system? So basically a clarification of the difference between the patenting on plants and parts thereof versus what is granted through the plant breeders' rights protection. I'm not sure if that's part of your portfolio in the office, but perhaps just from the patent aspect, if you can mention, what are the key criteria as you spelled out for what might be patentable or not with regards to plant or parts of plant materials.
For us, regarding the patent examiner, the plant or plant varieties can be patent or their products or plant materials. We can protect all of this under the plant, and the plant varieties we suppose is to be under the plant. This is not the specialty for the patent examiner, but the Office of Patenting the Plant Varieties here in Egypt, not the Egyptian Patent Office. Plant or plant varieties can be patent.
Yes, as you mentioned, subject to the conditions as you described. Yep. So I think we've come to the end of our webinar. First of all, again, to give thanks to the support of Oxfam Novib to the study that was presented by Professor Correa, that it was possible with that support of Oxfam Novib together with the Swedish International Development Cooperation Agency and the Ministry of Foreign Affairs of the Netherlands. And so, of course, suggest for those who have not had the chance to read it to please go ahead, and we added the link to that. I think the general point I take away from the discussion is really that there's a clear agenda that needs to be advanced. A lot of clarifications that can be made on the subject matter. We see that clearly from the EU practice in law and case law. There's a lot that is in line with already existing international instruments that developing countries can themselves use this policy space, regardless, of course, as what we've heard of potential many limitations of, but clearly there is this agenda that can be advanced. So we hope that this is an opening for that. Secondly, we see, as this was a side event to the WIPO Standing Committee on Patents, that we hope that this can also bring ideas to bring this discussion forward, as that's a forum for discussion on issues about substantive patent law. And finally, just to mention that South Center can provide technical and legal advice to policymakers for an analysis of the current legal frameworks, as well as recommending options within that scope of the particular national context. So with that, thank you all very much. Professor Correa, if you'd like to say anything closing for the South Center as well as panelists.
Well, just to thank our distinguished panelists. They have made a fantastic contribution for the understanding of this issue. Certainly, I think that there is a need, as you mentioned, Viviana, to advance an agenda for developing countries to look at this. There has been a lot of focus on patents and access to medicines. We need to work more on this issue. Is crucial for development of agriculture, for access to seeds. So I hope that we can continue working on this, and then looking into some specific areas, as one of the questions has suggested, what will be the future of patent application based on the new technologies, the gene editing creeps. I think that is very important to provide some guidance to patent offices and policymakers in developing countries in this matter. So thank you very much again to those participants also and our speakers. You are muted, Viviana.
Yes, just in closing, thank you all again. Thank you very much for participating, and see you again. And we will make the recording available and presentations as possible. Thank you.
Okay, bye-bye.